Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Sorry, let me move that really quick. We're not going to start reading until we'll give it like a minute for people to filter in, because whenever something breaking happens, I'm always coming in the last second or like the first second. I'm not sure, but I'm coming in as fast as I can, basically. And then I know people weren't expecting the live, so I want to give everyone a chance before I start reading. So we'll give it 1 to 2 minutes. But I do want to, in the interest of transparency, let you all know that I did, at this hour of 8:28 p.m. here in Florida, start this stream off by saying good morning. However, I forgot to hit the start button, so nobody would have known that, but I really wanted to get it off my chest. How's it going, guys? We have let's see, it's a 55-page filing here. And this will be Justin Baldoni's, let's see, it's opposition to the motion to dismiss, the motion for attorney's fees and costs, and to strike Exhibit A. So the response to the Publicist's motion to dismiss, which was filed, it has been a couple weeks now, maybe. But, yeah, that was, that motion to dismiss was filed by Leslie Sloan and Vision PR. Let's see. Hey, guys. I see we got a pretty decent number of people in here, so I'll wait just another minute, okay? LOL, you need sleep. I was actually laying down, and then I saw this had come up on Phaser, so it should come up on Court Listeners soon. They're usually not far behind, but if not, then I'll post this document. Like I said, I always post them on my YouTube page under posts, I put them on my X page. Hardworking today? Yeah, this is my third stream of the day. So, I mean, I've done worse, you know, I think. I'm not positive, though. Hey, Winks, what's up? Hey, Zach. Thank you, mods, for being here. I think I saw Teresa up there. Sarah joined us for a second, but she had to go to bed. I miss Bruce. Lauren, how do you get through the day with such little sleep? You must drink a lot of coffee. I actually don't drink coffee, like ever. So when I do drink coffee, it's like a war zone in my brain. So I just don't do that. Yeah, every now and then I'll have a 5-hour energy. I used to drink those like crazy when I was younger, like swim meets and stuff, especially at like college meets. When I got older, I don't know, I felt like it was like a ritual. I would have a 5-hour energy shot before prelims of a meet, a 5-hour energy shot before finals, but I didn't want everyone to know that I was drinking so much caffeine for some reason, and so I used to hide it in my parka, and then I would go in the bathroom, and when I was changing into my suit, I would like covertly take this 5-hour energy because I didn't want anyone to judge me. It's the stupidest shit ever. Like, who cares? Is there such thing as toxic positivity? Also, are they starting to dig in through Justin's medical records? Is there such a thing as toxic positivity? Yes. Is it what was described in the LA Times article? No. Yeah, we'll get into that another time. Looks like we're doing pretty good on our numbers here. So let's we'll wait. Let me give it 30 seconds and then we'll start, okay? Sorry that random people are saying random things to you. Well, if you guys... So I was actually on Omar's stream last night until like 2 a.m. going over some stuff with him. And I said this, and some of you guys probably don't know. I've been saving screenshots of like some weird comments. Like, I don't save the really disturbing ones, but I save the ones that are just like weird or like a little rude. And I'm going to do like a Lauren reads mean comments, like kind of like a Jimmy Kimmel, you know, celebrities read mean tweets or whatever. Maybe I'll see if I can get Dave to do that too. So you guys will see some of them for sure. And don't worry, I screenshotted the whole "you work for Taylor Swift because your dog is white" thing. So, all right, I feel like I've talked long enough at you. Let's read this document. I was asked to mute when I hydrate, so I'm just letting you all know I'm making a conscious effort to do that. All right. Can you guys read that okay? I think the text is big enough. All right. And like you guys know, I always tell you, anyways, I'm not a lawyer. I'm not a judge. Thank God. That sounds like a lot of reading. So that's why this is the court of random opinion. So when we get to some of this case stuff, the case citations, I might skim over some of it and refer you to my friend Omar, the Tilted Lawyer, for that. And see what he has to say about it. In the chat, I'm going to put a poll. Do you want me to invite Omar in here right now, or should we wait for history? I mean, he might be busy anyways. All right, chat, vote in the poll. Okay. Sorry for, I know some of my new viewers every time always get annoyed with me talking, but this is not my day job. This is what I do in my free time for fun, so you will get a little bit of my personality. Bear with me, or don't, but leave quietly, please. All right. Memorandum of Points and Authorities Introduction. As alleged in the Wayfarer Party's first amended complaint, the Sloan parties played an active and integral role in a conspiracy to inflict harm on the Wayfarer parties. The conspirators first aimed to win plaintiff Blake Lively total control over the film It Ends With Us, by means of extortionate threats to go public with her baseless claims of sexual harassment. That effort wholly succeeded. Having seized complete creative control over the film and its marketing, Lively had only herself and her publicist, Leslie Sloan, and Sloan's company, Vision PR Incorporated, to blame when her disastrously tone-deaf marketing efforts for the film plowed her public reputation straight into the ground. Whoa. That was some beautiful wordsmithing. Oh, no, they're not going to like reading that one. In a desperate effort to salvage Lively's reputation and to escape her wrath, the Sloan parties conspired with Lively and consolidated defendants Ryan Reynolds and the New York Times to make scapegoats of the Wayfarer parties for Lively's woes. This is crazy, man. I'm really appreciating how entertaining this is to read, because I know some legal documents are just not it. But every single filing in this case that I've read, I feel like there's been something that I've just been like, what did you just say? All right, how's the poll looking? We got 92% yes, invite Omar, the Tilted Lawyer. So let me text him. Reading new filing. Okay. I mean, Omar's a whole father with kids and stuff, so he might not be able to join us. But let's send him a link real quick, and then we'll continue on to this wonderful, beautiful piece of writing that we've seen so far. Wow. You know what? I'll copy Dave on this too, because I don't know if he's got this document yet. Invites. Let me text him. Sorry, guys. I know I'm taking a minute here. Okay. All right. Sorry. Back to my people. It's the response to Leslie Sloan. Yes, correct. And so the Publicist, you know, they had filed the motion to dismiss first. The New York Times motion to dismiss didn't come until later. So this is the first one they have to respond to. There are multiple parties now that have made a motion to dismiss. So Plow should totally be part of the live stream name. It should. I'll have to work that in somehow. All right. As a direct result of the actions of Sloan parties and their co-conspirators, the Wayfarer parties have been damaged beyond measure. Their reputations are destroyed, their businesses lie in tatters, and their own film was taken from them. These are the facts underpinning the Wayfarer parties' allegations against the Sloan parties, and this is what the evidence will prove at trial. The motion should be denied in its entirety, Or, in the alternative, the court should grant the Wayfarer parties leave to amend their first amended complaint and allow them to move forward with holding the Sloan parties to account for their part in Lively's malicious and calculated scheme. Oh, this is so dramatic. I love it. Guys, I don't know why, but as I'm reading this out loud to you, I have Perez's voice reading it into me in my head. Oh, man. B. Mahone says, this is the funniest chat group. I agree. I really enjoy having all you guys here to listen to me, even though I know there's a bunch of people who are like, Lauren, shut up and read the filing. The only reason I'm here doing this as fast as I do is because I love this little community that I have now, and I never imagined it. So it's just been such a pleasure, even with the hard stuff, because, you know, I'm still learning and all that. But it's been such a pleasure. I appreciate you guys. All right. Lively chose New York as the forum in which to bring her evidence-free claims against the Wayfarer parties. Although none of them are New Yorkers, the Wayfarer parties stood ready to defend themselves in any forum, and accordingly brought their own claims in this court. But because the Wayfarer parties suffered their damages in California, where nearly all of them make their personal and professional homes, they are entitled to bring their claims under the laws of California, which has a manifest interest in protecting its citizens from defamation and other harms. Yet the Sloan parties insist that merely because they as defendants have chosen to make their homes in New York, they are entitled to the full weight and protection of New York's laws, regardless of the fact that they reached out across the country to inflict grave and insidious harm on the Wayfarer parties in California. California law should apply to remedy the wrongs suffered in California by California residents and their associates. The Sloan parties complain that they are unable to distinguish the allegations against them from those brought against other parties, arguing that the Wayfarer parties engaged in impermissible group pleading. Of course, it is premature at this stage to require the Wayfarer parties to specify the precise acts taken by the Sloan parties in connection with their conspiratorial scheme. A jury will determine the truth based on the evidence, but until then, the Wayfarer parties have done more than enough to make their allegations against the Sloan parties clear and can easily amend their pleadings to add further details based on what they've already learned. Whew. Let me take these off because it gets hot upstairs in my house, and I'm like I keep telling you guys, I'm just a random person in my attic. Like I'm not a professional. I don't have a studio. I'm just a person in my attic, and it gets hot up here sometimes. So, all right. Let's see. And by the way, guys, I don't know if you heard the public hearing today before the live streams got taken down, which, as hopefully as most of you know by now, I did not know you were not allowed to stream that because I've never done this before. So like I've done one court case in my life, and it was one that I went to in person, and the judge approved me to film that. So like, yeah. Anyways, after that got taken down, I don't know how many people missed it, but the attorneys for the publicists, this one in particular, they like to say like, our client is dragged into this for no reason. And this is the same one in the February 3rd hearing where we got the transcript that we read, was saying my client and her woman-owned business, they had no business dragging them into this, basically. So just to let you know, that's who they're responding to in this filing that we're reading right now. Karen Carson, thank you for the 5. I've been missing the live so much lately. I've missed listening to you laughing at the craptastic things we follow. Yeah. All right. Let's see. There is a footnote here, so I do want to just double check and make sure I don't skip over anything. I have a hard time remembering to read the footnotes, guys, so I'm sorry about that. Let's see, the footnote was up here. 1. Where did that go? Where's footnote 1? You know what? Why don't I just read the footnote? Because the Wayfarer parties have already once amended their complaint. It is the Wayfarer parties' understanding they do not have the option to amend as of right pursuant to Rule 15. Out of abundance of caution, therefore, the Wayfarer parties oppose the motion and the relief sought therein, and urge that, if the motion is not denied outright, it be granted only with leave to amend. I see. Okay. And then here's number 2. Steve Sarowitz, the lone exception, is a citizen of Illinois. So they're talking about the jurisdiction type stuff, or the rules of which state apply. But he is a party to this action solely by virtue of his ties to the California-based Wayfarer parties. As argued herein, the court can and should apply California law to all the Wayfarer parties' claims. Certainly, the Sloan parties make no argument that Illinois law should apply. Well, why not make that argument, right? Since their woman-owned business got dragged into this and they have nothing to do with it. Oh, man. Panda Bear, apparently not. So I didn't know that. But I get so many trolls now in my chat that I'm not used to because I've never had a real audience before. So that I didn't know like what to really think of it. So I emailed the court after I had streamed because I missed the part of the call because I hadn't dialed in yet and I was busy scrambling trying to figure out how to dial in. And where they said, you know, don't record or whatever. So I emailed them and I was just like, hey, I had no idea like this happened, but do I need to take the video down? Because I totally will. I didn't say it like that. I was totally medium professional. And the court wrote back and they were like, hi, you know, like, yes, we would really appreciate it if you took the video down. And so of course I did, like right away as soon as I saw that email. And, you know, they were nice about it. Nothing bad happened. It's just, apparently you're not supposed to do that. So now I know. Anyways. Of course, it is premature at this stage to require the Wayfarer parties to specify the precise acts taken by the Sloan parties in connection with their conspiratorial scheme. A jury will determine the truth based on the evidence. But until then, the Wayfarer parties have done more than enough to make their allegations against the Sloan parties clear and can easily amend their pleading to add further details based on what they have already learned. Under either California or New York law, the Wayfarer parties have stated a claim for defamation against the Sloan parties. The first amended complaint adequately pleads that the Sloan parties made defamatory statements of and concerning each of the Wayfarer parties, either individually and or as members of a small and readily identifiable group. Those statements are not in actionable opinion because they are falsifiable to the extent they contain opinion. That opinion implies the existence of unstated but false and defamatory facts, nor can the statements be held to be substantially true on the face of the pleadings, because the pleadings set forth a sequence of events entirely inconsistent with the false statements made by the Sloan parties. The Sloan parties' false claims of sexual assault are sufficiently specific to constitute defamation, and the Wayfarer parties need not plead special damages because those statements and others are defamatory per se. Finally, the Wayfarer parties pleaded facts sufficient to allege that the Sloan parties had the requisite state of mind to defame, even under the challenging actual malice standard needed to defame Baldoni, a public figure. And like I said, I'm not going to lie to you guys. I don't know all the rules of the standards and anything like that. That's why I'm trying to get one of my lawyer friends to join us. So yeah, we'll see. Ella Ruisi, I hope I said that right. I fucking love when you giggle. It makes this craziness even better. Well, I have a feeling we're going to hear more of that. I really enjoyed this channel referred by Dave Neal. Keep up the good work. Dave is actually probably the reason I have a YouTube channel at this point. So like I had a YouTube channel to make just like bad Fortnite clips and play games with my friends. You know, like I played like Jackbox games with my friends and family. And then I made a video one time talking about something that Dave was covering and he, you know, got me to keep going. So yeah. Let's see. The motion falls short with respect to the Wayfarer party's claim for false light invasion of privacy as well. The Sloan party's primary argument that New York law, which does not recognize false light claims, must apply, fails for the same reasons that California law must govern the Wayfarer party's defamation claim. Having made their personal and professional homes in California and having suffered considerable harm there, the Wayfarer parties are entitled to the protection of California laws. The Wayfarer party's claim for false light invasion of privacy satisfies the... What? I'm not going to lie to you. I don't know what the hell that is. Let me Google this. The Twombly something else standard is the U.S. Supreme Court ruling that requires plaintiffs to show that their claims are plausible. Okay. This standard makes it harder to sue in federal court. I still don't know how to pronounce that, but okay. Now I know what it is. All right. Privacy satisfies the Twombly word standard for specificity and plausibility of pleading. The Wayfarer parties have done more than enough to give the Sloan parties adequate notice of the allegations against them, and the claims are amply supported by plausible factual allegations sufficient to state a claim for false light. But if the court determines the further factual allegations are necessary to satisfy the pleading requirements, the Wayfarer parties stand ready to supply them by amending their complaint. So you know how they had also said to the judge they could potentially amend their complaint against the New York Times because the New York Times had raised a motion to dismiss. Now they may also have to take this into account if they have to provide more detailed information to bolster their claims. So... Swamp dudes. All right, let me put... I think we're good on the poll, guys, so I'm going to end the poll. I did invite him, but I think he might be busy because in California it's only 5:48. So, and I'm in Florida. All right. But if the court determines that further factual allegations are necessary to satisfy the pleading requirements, the Wayfarer parties stand ready to supply them by amending their complaint. The motion again misses the mark when it comes to attacking the Wayfarer parties' claim for civil extortion. Again, the Sloan parties insist that New York law, which does not recognize a claim for civil extortion, must apply, an argument that once again fails. The Sloan parties claim that the Wayfarer parties failed to allege that the Sloan parties received anything of value as part of their extortionate conspiracy, but this is not a necessary element of a claim for civil extortion under California law. Furthermore, the Sloan parties err in arguing that they can be held liable for civil extortion only if they themselves directly used force or threats to obtain property from the Wayfarer parties. Like all torts, civil extortion may be pleaded on a theory of liability by conspiracy, as the Wayfarer parties have done, by pleading that Lively, Reynolds, and the Sloan parties acted in concert to extort the Wayfarer parties. The First Amendment complaint sets forth allegations sufficient to survive a motion to dismiss the claim for civil extortion. All right. Even if the motion is granted, it should be granted only with leave to amend. Federal courts apply an extremely liberal policy in favor of amendment under Rule 15 of the Federal Rules of Civil Procedure. The Wayfarer parties have already learned substantial additional information since filing the First Amendment complaint that would enable them to plead further facts in support of their claims based on their own investigation and on facts drawn to their attention by concerned citizens from around the country and beyond. Should the court not be inclined to deny the motion in its entirety, the court should grant leave to amend so that this action can be decided on its merits at trial. As part of that amendment, the Wayfarer parties would endeavor to judiciously incorporate the fulsome chronological account and evidence set forth in Exhibit A to their First Amendment complaint and to the body of the complaint itself, to minimize the burden facing the Sloan parties as they attempt to counter the admittedly daunting mountain of evidence against the defendants. Holy fuck. Finally, even though the motion should be denied, or at most granted only with leave to amend, under no circumstances are attorney's fees or costs available to the Sloan parties. Courts of the Second Circuit and of this district are nearly unanimous in holding that the state anti-SLAPP laws of California and New York, which may allow recovery of attorney's fees, are entirely inapplicable in the federal courts because they conflict with the standards of Rules 11, 12, and 56 of the Federal Rules of Civil Procedure. In short, the motion should be denied, and the alternative, the court should grant the Wayfarer parties leave to amend their complaint because any defects in the First Amendment complaint are easily cured based on the facts now available to the Wayfarer parties, so we should be able to plow right through that. That last sentence I made up, but I liked them when they said plow earlier, so I decided to put it in there again. Man. Hey, Lala, I keep forgetting the name of this channel, and I'm so happy I see it on my notifications, even though it keeps unsubbing me. Dude, YouTube's crazy with the notifications and the subs and stuff like that. So Zach Peter, I've been subbed to Zach Peter for a while, and I went today and I saw Zach Peter was live, and I was like, why the hell am I not subbed to Zach anymore? So and the same thing has happened with Dave. The same thing has happened with that Umbrella guy. So, YouTube is just all over the place with some weird shit, but it is what it is. But yeah. Just for the record, I'm watching you, Lauren, with an eye shut because it's 2 a.m. here. I look like Popeye. That's the level of commitment I have at the moment to this cause. Yo, I got you. Zach is such a cutie patootie. I think Zach's cool. Yeah, I watch his stuff. I'm very busy, so I didn't get to watch a lot of stuff. So mostly I watch his like Instagram clips and stuff. So, but he's cool. He's pretty funny. If y'all click those emojis on the side, it helps the algorithm. I don't even know what that means, but do what she says. Yeah. Okay. Let me see. Give me 1 second, guys. Sorry, one second. Bear with me. I guess this would be a good time to hydrate while I'm eating. You're welcome to whatever commenter was complaining about that. All right, I'm back. I just heard of Zach this week, and I'm usually lost in true crime. Gotcha. Okay. Dana, Andy, and Zach all live stream together. I saw some of that, but I was working, so I couldn't really watch. Okay. Legal standard. And this is where, guys, I'm going to start skipping around a little bit because, I'm not going to understand all the case stuff, but I will do my absolute best. So, to survive a motion to dismiss under Rule 12b-6 of the Federal Rules of Civil Procedure, a plaintiff must state enough facts to state a claim to relief that is plausible on its face. A claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. A complaint will be dismissed where the allegations in a complaint, however true, could not raise a claim of entitlement to relief. In ruling on a motion to dismiss, the court must accept the plaintiff's factual allegations are true, drawing all reasonable inferences in favor of the plaintiff. Courts apply an extremely liberal standard for amending pursuant to Federal Rule of Procedure 15A2. Okay. Oh, that was it? Okay, cool. I think this is where we get into the good stuff, factual background. Justin Baldoni is a well-known actor and film director who co-founded Wayfair in 2019. Wayfair acquired the film rights to Colleen Hoover's novel, It Ends With Us, in 2019. The book explores themes of domestic violence and generational patterns of abuse. Soon after, Wayfair partnered with Sony Pictures Entertainment to co-finance and distribute the film. Baldoni took on the role of director, as well as male lead character Ryle. On or about December 31st, Blake Lively agreed to take on the lead role of Lily Bloom. She was granted an executive producer credit, but Wayfair neither requested nor required that Lively contribute to the film in any capacity other than as an actor and executive producer, a vanity credit with no direct responsibilities. It initially appeared that Baldoni and Lively would have a productive working relationship as they collaborated closely in the early days of the production. Okay. However, Lively soon began intruding into the production process in ways well beyond the scope of her contractual entitlements. She took over her character's wardrobe, we know about that, yeah, and exploded the budget for the role, for example. She also insisted on taking over writing multiple key scenes for the film, resorting to calling in her famous husband and friends as reinforcements when her script rewrites were not received enthusiastically as she hoped. She began altering the script daily. Pre-production and the first phase of filming were tenuous, with the Wayfair parties tiptoeing around Lively to avoid incurring the wrath of Lively and Reynolds, resulting in delays and significant financial losses and a delicately scheduled production. And guys, where you see this like FAC here, that means First Amendment Complaint. So we have all the filings from that available to us. And then if you want to read this after, if it's still not on Court Listener especially, I will upload it to X. Sorry, I keep forgetting because it's not Twitter. To X. And also to my YouTube page under the post tab. And you can compare Like look at what they're saying here and then go to the paragraph cited from the First Amendment complaint, and you can like compare what's being said and what they're like citing and that kind of stuff. So if you see this, Lauren, can you make the text a tiny bit bigger for my not so great eyes, please? For you, okay. That might be a little too big, I'm not sure, but we'll go with it as long as you guys can see it. All right. Delays. Okay. At one point, Lively issued an ultimatum that if Baldoni could not get on board with her work methods, he may have to recast her role. Oh, shit! Oh, no. Okay, yeah. No, I think we probably did read that somewhere, but I didn't really notice it before, you know what I mean? I didn't really think about the gravity of the situation. Wish you just like do it or else. No, I probably did read that before, though, because that all makes sense in context. Sometimes, guys, when I've read hours and hours of these filings, I forget little details. So when I see them again, I might freak out a little bit. But yeah, I'm pretty sure we knew that. Didn't we know that? Chat, if we knew that already, put a thumbs up. If we didn't know that already, put a bunch of bacons. All right. Lively issued an ultimatum that if Baldoni could not get on her board with her work methods, he may have to recast her role. Still, Lively reflected a casual, frank manner on the set, for example, inviting Baldoni to join her in her trailer while expressing breast milk, and it using terms such as sexy that she later castigated others for using. I remember that. I'm seeing one thumbs up and I'm seeing some more bacons. More thumbs? Okay, so we're 50-50 on that. Okay. In May 2023, while filming was underway, the Writers Guild of America went on strike, followed shortly thereafter by SAG-AFTRA strike in July 2023, which caused a hiatus in production pending resolution of the strikes. As Baldoni began editing the footage already shot during the strike break, Lively began insisting on access to the dailies. The Writers Guild of America strike ended in September 2023, and the SAG-AFTRA strike ended on November 9th. The same day the SAG-AFTRA strike ended, Lively's lawyer sent an unexpected and confusing 17-point list of non-negotiable demands that must be met before Lively would return to work, apparently drafted for the purpose of falsely insinuating that Baldoni, Wayfair CEO Jamie Heath, and others had engaged in sexually inappropriate conduct during filming. An entirely false claim. While the Wayfair parties disputed, and still dispute, that Lively's demands had any legitimate predicate, they nevertheless found the request largely unobjectionable. Oh my God, Lauren. Unobjectionable. Sorry. I'm really tired. And frequently consistent with existing practices. The discussions over Lively's terms for returning to production culminated in an all-hands meeting on January 4th at Reynolds and Lively's apartment, where Lively made additional false and unfounded accusations, and where Reynolds aggressively berated Baldoni for his purported transgressions, an event that left all the attendees from Wayfair and Sony shaken and disturbed. Shaken and Disturbed is the name of my band. I'm suing. No, but also, this is like when I first started reading these filings, and like none of you are going to remember this because I had such a much smaller following back then. But when I first started reading these filings and I was reading about how they like forced them to go to their house to have the meetings, or their residence to have the meetings. What was the word they used here? Hang on. All hands meeting at their apartment. Okay. But it's not just an apartment. It's a penthouse. So this is why I was reading this and I was thinking, what out of touch rich people, what must it be like to be an out of touch rich person like that, and to have, someone you're supposed to be working for, and to hold something hostage from them to the point where they have to be like, please sir, some porridge, let me into the penthouse so I can have some porridge. So yeah. That's all I remember from that. I get it. I get, how things work in our country and all that. So I'm not trying to get political or anything like that, but I feel like really rich people, they are very out of touch with like the regular everyday struggles of life. So when they like forced them to go to their penthouse, I was like, really? You couldn't have gone down to the studio to have a neutral meeting with these people? Like, seriously? Anyways. Please, sir, please let me in the penthouse. I think Patreon was the only notification action I got for this live, not YouTube this time. Join Lauren's Patreon for an extra notification in case. The Patreon is free. You don't have to pay for the Patreon to get announcements. Teresa and mods, if you could put links to a link to the Patreon in the chat so people can sign up for that and they'll know when we're going live from now on. Traveler landed. I think Lively has mental health issues. Ryan also. So while I'm taking a short break from reading this, if you guys don't know, if you haven't seen me before, like I said, this is the Court of Random Opinion for a reason. I'm not a lawyer. I'm not a judge. I'm just a random person in my attic. But what I do is I've worked in healthcare for a very long time, mostly in psych. And I work in acute psychiatric crisis. So when a patient is in crisis and they're taken to the emergency room because they're going to hurt themselves, hurt someone else, or they're psychotic or something like that, they need someone to evaluate them and decide if they need to be committed, basically, against their will. And so I did this video, I want to say a couple weeks ago now, because I saw people were saying, like, oh, she's insane, she should plead insanity. And then I saw Dave's clip of the comedian, I forgot her name, Whitney something, saying Blake should plead insanity, which, first of all, this is not a criminal trial. But second, she's not insane. She's just an asshole, in my opinion. And that's not my professional opinion. This is not reflective views of my employers, just mine. My personal opinion is that she's not insane. She's just an asshole. And that's the case for a lot of people. And I feel like a lot of laypersons don't understand the difference between truly criminally insane and actually just like you're a dick. So, but yeah, that's what I was going to do. Mental health issues, though, I agree. There could be some personality disorder there for sure. Absolutely. That's what I'm seeing. I'm seeing like some clustered traits of personality disorder. I'm not seeing psychosis. So, first of all, not a criminal trial. Second of all, she's not psychotic. She's just a psycho. All right. Anyways, let's see. So we got to the confusing 17-point list. Okay. We got through that. The discussions over Lively's terms for returning to production culminating in an all-hands meeting on January 4th. Yeah, we got through the penthouse. The penthouse, please, sir. The porridge. Okay. Where Lively made additional false and unfounded accusations, and where Reynolds aggressively berated Baldoni. As Lively admits, however, filming proceeded thereafter uneventfully through the second phase of production, without any further purported incidents of which Lively could complain. However, Lively seized on the opportunity to use her new ammunition, a carefully constructed paper trail of false insinuations and claims, to complete her forceful takeover of the film from Baldoni, based on the implicit and ever-present threat that she must have her way, or she would ruin the Wayfarer parties. Gradually, but in the end completely, Lively took over the editing of the film, ultimately extorting Sony and Wayfarer into releasing her cut, despite its poor performance with audience tests. She also dictated the film's marketing, erasing Baldoni from promotional material and driving the lighthearted, frothy campaign. Frothy campaign. Oh, man. For the film while peddling her own products. A decision that proved disastrous for her later on. She continued to insist on greater credit for the film, demanding that the Wayfarer support her request for the coveted PGA mark, despite not having earned that credit, which denotes a producer who performed the majority of producing work on a motion picture. And the frothy thing really got to me there because my dog stays at my parents' house a lot because my sister lives with my parents and they're just down the street. And they like to hang out together. They don't like to be apart. And so every morning when my mom has her coffee, they have something they call a froth party. A froth party. Basically where my mom scoops some froth out of her coffee and they eat it off her finger. And so now when I see frothy, now in the total context of everything I just told you guys 5 minutes ago, please let me into the penthouse to have some froth. Oh, man. All right. Moving past the frothiness, the froth party is over. Anyways. She continued to insist on greater credit. We got through that. As the premiere of the film approached in the summer of 2024, Lively told Sony that she and the rest of the cast would not participate in any marketing and promotion of the film alongside Baldoni, deliberately creating the false impression that Baldoni had committed some serious offense. On information and belief, Sloan, okay, thank God we're getting back to Sloan because I was starting to think, why are we not talking about the Publicist? On information and belief, Sloan was throughout this time working to spread false and defamatory allegations against the Wayfarer parties to members of the press, both defaming the Wayfarer parties and serving as the muscle behind Lively's coercive threats. Upon information and belief, this began well before the backlash against Lively for her wrong-headed marketing efforts for the film, not to mention the self-promotion of her own alcohol and hair care brands. And if you guys didn't see the stream earlier today before I had to take it down, I set a goal for the super chats, and I said if I reach this goal, I will try Blake Lively's hair care line and give a review of it. So we did meet that goal. So look out for that. As soon as I get some of that hair care line, I will use it and let you know what I think. But like I've said before, if you want to be a successful person in the cosmetic industry and you're trying to sell a hair care line, even if you're a hot blonde, you can't have frizzy ass hair everywhere you go. And every time I edit one of my thumbnails, I have to erase her frizz. And she is, like I said before, an objectively beautiful person, gorgeous, nothing's wrong with her appearance. However, if you want to market a hair care line, maybe don't. You know? So, oh, man. Can we get the like count up, please? It makes us sad if less than 50% ratio. We need a bunch more likes. Well, I blame that on you, Teresa. So you better work on that. Oh, man. Where are we at now? Let's see. On information and belief, Sloan was thought that. Yeah, okay. Upon information and belief, this began well before the backlash against Lively for her wrong-headed marketing efforts for the film, not to mention the self-promotion of her own alcohol and hair care brands. The FAC details the information known to the Wayfarer parties at the time of filing about the Sloan parties' activities to defame and extort them. Since filing the First Amendment complaint, the Wayfarer parties have obtained additional information about the Sloan parties' activities during this time and will, if granted leave to amend, add those allegations and their amended pleading. Well, I'm pleading for you to do that because I want to read it. Oh, man. As Wayfarer and Baldoni drifted away from their increasingly erratic publicist, Stephanie Jones, of Jonesworks LLC, which, if you haven't read the Stephanie Jones lawsuit, it's nutty. Read the Stephanie Jones lawsuit. I'm not rooting for anyone in that lawsuit. Everybody comes across like hot trash, but it's an amazing read. I'll give you that. So, all right. Jones reacted with vitriol. She seized the phone of departing publicist Jennifer Abel, who was serving as Jonesworks' assigned point person for the Wayfarer account, mined it for what she believed to be damning information, and immediately turned over that information to the Sloan parties. The same day, Sloan called Melissa Nathan and told her that Sloan had seen Nathan's text to Abel and that Nathan should expect to be sued. So, now that I have gone through the Publicist lawsuit, I do want to say before we move on with that, think of this lawsuit that we're referencing right here as a separate lawsuit between the publicists. So Jones and Jonesworks, the former publicists of Justin and Wayfarer, and Abel and Nathan, the now publicists of Wayfarer and Justin Baldoni. Justin is named in that suit. Wayfarer is named in that suit, but most of the damning information seems pointed towards Abel and Nathan. And so that stuff, it all seems to be like contractual breaches. And so Stephanie Jones, as erratic and insane as she may be, and as crazy as her lawsuit is, does actually seem to bring some valid points of contractual issues with Abel. As far as the Wayfarer parties, I really couldn't say if she has a claim against them that it really makes sense to me, because I haven't seen much evidence to that effect. However, as far as the Stephanie Jones lawsuit against Jennifer Abel, I definitely see that, because Jennifer Abel made tremendous mistakes with that phone, because people get confused about this. The phone was actually company owned. So the phone belonged to Stephanie Jones, the device itself. So like this phone, say this is the phone. This, if I'm Jennifer Abel, this belongs to Stephanie Jones, but the phone number it's connected to that sends and receives information belongs to Jennifer Abel. And for some reason, I agreed to that when I signed up to work there. Now, when things are going sour, Stephanie Jones starts to get paranoid and suspect things. And in this case, it just turns out she was probably right, even though she is a little nutty and has other issues. I'm separating those from this specific lawsuit. So Stephanie Jones gets the phone back, and then she holds the line hostage. So Jennifer Abel, who is now going to start her own business, wants to keep that phone number attached to all her clients and everything, and put it on a new device. So it would be like if I picked up, like, say this was another phone. Here's the old phone, which was owned by the company. The company, as promised, I guess, would then shut the phone number off. So this is just a device now that's just holding information that was on it. This here, the new device, is now connected to that phone number. So I can contact old clients and stuff from this new phone with the same number and continue about my business. However, the issue is this phone, which had the number attached to it, belongs to Stephanie Jones. So Stephanie Jones can go to Cellebrite, which is the company that can do like forensic cell phone extraction and stuff like that. And because it's a company-owned device, because it's her device, she does not need a subpoena for that. So Stephanie Jones can get the information off that phone, all the text, even the text that have been deleted. That's what Cellebrite does. It gets everything. And that's how criminals get caught a lot of the time. So they get the phone. They use the Cellebrite because she doesn't need permission from Jennifer Abel to use the Cellebrite on her own phone, regardless of the fact that it was her number. And she gets everything. So my question then, if that is, in fact, if I'm not saying there's not something I've missed, because it's possible I've missed something. If that is in fact the truth, if that is in fact how Stephanie Jones got all those messages, my question then, because Justin Baldoni and Wayfarer had left them and were still with Jennifer Abel, but for a different agency, why then, in this short window of time when all this was crunched together, allegedly, did Blake Lively subpoena that information from Stephanie Jones rather than try to get information from Jennifer Abel? Because the way they got those text messages and all that evidence, they got it from Jones Works. They didn't get it from Jennifer Abel, to my knowledge. I could be wrong, but that's, to my understanding, that's what happened. So anyways, I know I was rambling a lot there, but I just wanted to kind of explain my thought process. Have we read that one already? Sorry. KKB, thank you for the 10. PS, I'm totally okay with not supporting BL hair products on principle alone and taking a replacement goal. I don't know what the replacement goal would be, but I'll think about it. Thank you. Jacqueline Jackson, thank you for the 5. I'm sure Sloan had connections with Megan Twomey. Sloan probably fed Weinstein stuff to Megan. This Blake article was the devil asking for his due. Yeah, so the thing is, even with the connections and stuff like that, she would have to outright come out and say, like, or like imply or have them somehow know telepathically that she has that information, they should subpoena her for it. And that's just my interpretation of things. Like I said, there is a 100% chance I could be wrong. So take that as you will. But So she got that stuff without a subpoena because she didn't need it. It was her own device. But then how did Blake Lively know to ask for that, to give it to the New York Times, and for them to put all of that together within a very short time frame when they claim to have gone through thousands of text messages? It doesn't add up. But yeah. And for the record, apparently you can have your phone records subpoenaed, without you knowing. So, yeah. Okay. Kai, thank you for the $6.99. I appreciate for your hard work. I appreciate you for being here. Kai, thank you again for the $6.99. They said Blake subpoenaed it from Jones, but there were no active cases that went far enough for subpoenas to be issued. I don't think there was one. So when I was doing my research, you can, in fact, get a subpoena without a lawsuit. So before a lawsuit is filed. And I don't want to talk about this too much more because I know there's people who just want to hear me read the document, and I'm not going to try to drone on for too long, but you can get a subpoena without the lawsuit being filed. You can get it as you have a precursor to the lawsuit, and you can get the subpoena to get the records, the evidence. And if you look at wow, sorry, Lauren, words. If you look at the lawsuit that Jed Wallace filed against Blake Lively in Texas, so not this one, she's named Jed Wallace in this combined case, but not this one. We want to look at the one in Texas. Jed Wallace attached copies of Blake Lively's CCRD complaint, precursor, among other things in that. And if you see the precursor, it's basically her first complaint. It's basically the same thing. There's some tiny differences, but it's basically the same. And so with that precursor, she then probably got permission or a subpoena in California to get those records. Or possibly in New York, I'm not sure, but we can't see that. We don't see, even now on the docket and Pacer, we don't see all the subpoenas that have been served and stuff like that. That's why when the Daily Mail came out and said Taylor Swift has been contacted for deposition, there's stuff we don't know. There's stuff about discovery and all that we don't know. So what judge would sign off on a pre-case subpoena? It does happen. It does happen. I don't think it's super, super common, but it does happen. And think about it. We're talking about two people who are very powerful in Hollywood, Ryan Reynolds and Blake Lively. So all of their lawyers say no. Well, I mean, I guess we'll find out when it comes out, but to my knowledge, you can, in fact, get a subpoena before the lawsuit is filed. CRD complaint does not address smear campaign. We're not going to get into all that. It does. So you have to read the precursor, but we'll do another stream about that to answer questions later, because I don't want to keep everyone waiting here and to listen to me drone on about this other stuff. So, but yeah, if you're following me at all, to put it as quickly as I can, my timeline is Justin leaves JonesWorks. Because Jennifer Abel left JonesWorks and he wants to stay with her. Jennifer Abel's phone, which was actually company property, stays with JonesWorks. JonesWorks gets the messages off the phone because it's their property and they do not need a legal subpoena for that. And then somehow, in my totally theoretical timeline, Blake Lively somehow finds out that she needs to subpoena those records from JonesWorks. You tell me how that happened. Connect the dots. But yeah, and no, we cannot see all subpoenas that are filed. As the public, I know a lot of records are available to the public. However, in lawsuits, we don't see all the discovery. We don't see all the subpoenas that are filed. Just like we saw the filings between Justin's attorneys and Blake's attorneys that were arguing about subpoenas, but we didn't actually see the subpoenas themselves. And even today, they were talking about subpoenas that we haven't seen. So we're not going to see all that. There's stuff we're not privy to. But if you connect the dots between all the filings and everything that we know, in my opinion, that's kind of how that went. In my opinion, all roads lead back to Stephanie Jones. Because I think that is how Blake Lively in the first place learned that she may have a case. And that is total speculation on my part, and I'm not a lawyer, and I might have it wrong, but those are my thoughts. So, moving on. Okay. As Wayfair and Baldoni drifted away from their increasingly erratic publicist, Stephanie Jones of Jonesworks, Jones reacted with vitriol. She seized the phone of departing publicist Jennifer Abel, who was serving as Jonesworks' assigned point person for the Wayfair account, mined it for what she believed to be damning information. And like I said, it actually was kind of damning information, just not against Justin and not against Wayfair, just against Abel. And immediately turned over that information to the Sloan parties. The same day, Sloan called Melissa Nathan and told her that Sloan had seen Nathan's text to Abel and that Nathan should expect to be sued. So, if Sloan had seen Nathan's text to Abel that same day, and Sloan and Vision PR represent Blake Lively, you do the math. Now, armed with Abel's private text message and communications, Lively and the Sloan parties worked hand in glove with the New York Times to concoct a story that would explain Lively's downfall by casting the blame on the Wayfair parties. After the Wayfair parties finally stood up to Lively and Reynolds and refused to accede to their final demand that the Wayfair parties put out a false and humiliating statement admitting blame and wrongdoing, the gloves finally came off. The Wayfair parties alleged that the Sloan parties colluded with Lively, Reynolds, and the New York Times over a period of months to develop a false and defamatory news article and video in conjunction with Lively's unfounded sham complaint filed with the CCRD. As a direct result, the Wayfair parties have suffered untold harm. So if you were listening to that entire long rambling rant that I went on just now, exactly what she's saying right here. Jacqueline says it was an unholy alliance between Sloan, Jones, and the New York Times. That's exactly what it sounds like. Because Leslie Sloan did not have access to those text messages at that time, ostensibly, unless she told her about it, unless Leslie told Jones about it. So, yeah. They were all with Sloan and then they parted. Yeah. So, well, they were all with Jones and then they parted. But Sloan is on the Lively side. Here's Jones, Abel, Nathan. And Nathan didn't work for Jones, but she worked with Abel on some stuff. Then Abel and Nathan separate from Jones. And then Jones gets mad, gets all the stuff off the phone. And then to enact her revenge, in my opinion, gave it to Blake Lively's side, Leslie Sloan. I don't know if that made any sense to you guys. I'm not very good at explaining. But if it did, that's great. Yeah. Somebody says it relied on Megan Toy not digging deep into the story. No one else would publish it. Well, yeah. She sucks. KP, thank you for the 5. BL's team outed themselves with Friedman's subpoena on Blake's security team. We would have never known. I have no idea what that was even about. So when they brought that up, I was like, what are you talking about? Anyways. Okay. After the Wayfair parties finally stood up to Lively and Reynolds, refused to blah, blah, blah. The Wayfair parties alleged that the Sloan parties colluded with Lively, Reynolds, and the New York Times over a period of months to develop a false and defamatory news article and video in conjunction with Lively's unfounded sham complaint filed with the California Civil Rights Department. As a direct result, the Wayfair parties have suffered untold harm. Here's the argument. That wasn't the argument? Oh my God. The motion fails entirely because it cannot show that the Wayfair parties failed to meet their pleading burden under Rule 12b-6. And you guys know I hated this word earlier and I hate it now. I'm going to call it the TI standard. How about that? And the TI standard. California law should apply to each of the Wayfair parties' claims, allowing the claims for false light, invasion of privacy, and civil extortion to proceed. But under the law of either New York or California, the Wayfair parties have pleaded a defamation claim against the Sloan parties sufficient to withstand a motion for dismissal. In the alternative, any defects or inartful pleadings in the FAC First Amendment complaint, can easily be remedied by amendment, which is liberally permitted, and the Wayfarer parties have gathered additional information sufficient to plead further specific facts to support each of their claims against the Sloan parties, as well as the necessity of applying California law to those claims. Furthermore, the Wayfarer parties can easily amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Finally, even in the extremely unlikely event that the court determines dismissal without leave to amend is appropriate, the Sloan parties are unable to recover their attorney's fees or costs, as neither California's nor New York's anti-SLAPP laws can apply in the Second Circuit. Okay. And these are it's breaking it down into more parts of the argument. How about a drink every time she says subpoena? Everyone would die. Sorry, man. All right. The problem I'm having now, guys, is I really have to go to the bathroom, but I don't have anyone with me tonight. So give me 1 sec. Oh, Dave's being held hostage by his baby, so he can't join us. Maybe I can get... No. If I have to, I will play a video for you guys while I go to the bathroom, but I'm gonna try to hold it. All right. The First Amendment complaint gives adequate notice to the Sloan parties under Rule 8. The Sloan parties first argued that the First Amendment complaint should be dismissed because it does not satisfy the minimum pleading requirements of Federal Rule of Civil Procedure 8 due to impermissible group pleading. See defendants... Yeah, I'm not going to skip over that. Under Rule 8, a pleading need only contain a short and plain statement of the claim, showing that a pleader is entitled to relief. Specific facts are not necessary. The pleading need only give the defendant fair notice of what the claim is and the grounds upon which it rests. To the extent that minimum requirement is met, the Second Circuit has noted that Rule 8 does not necessarily require that the complaint separate out claims against individual defendants. Okay. That is, nothing in Rule 8 prohibits collectively referring to multiple defendants, where the complaint alerts defendants that identical claims are asserted against each defendant. Okay. The question is ultimately whether the complaint gives each party notice of the substance of the claims against her. Okay. The First Amendment complaint gives the Sloan parties adequate notice. It alleges the existence of conspiracy between the Sloan parties, Lively and Reynolds, to seed a false and defamatory narrative concerning the Wayfarer parties to various media outlets, including without limitation the Daily Mail and the New York Times. In doing so, the Sloan parties and the Lively parties and the New York Times made a series of defamatory statements. These fall into two principal categories. So, as I read the Daily Mail, it's interesting to me because someone in the meeting today, I believe, implied that Friedman and the parties were making some sort of untraceable contact with media, like the Daily Mail, to give them information. So this is kind of like they're both saying you were talking to the Daily Mail. So, in doing so, the Sloan parties and the Lively parties and the New York Times made a series of defamatory statements. These fall into two principal categories. Allegations that certain of the Wayfarer parties, specifically Justin Baldoni and Jamie Heath, engaged in sexual misconduct towards Blake Lively. And allegations that Wayfarer parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation after she reported their purported misconduct. As alleged in the First Amendment complaint and discussed herein, those allegations are false, and the Sloan parties knew they were false. To the extent the Sloan parties are grouped throughout the First Amendment complaint with the Lively parties, that is because they are co-conspirators who engaged in the alleged campaign of defamation collectively. The precise contours of the conspiracy will come into focus through discovery. At this early juncture, and with some notable exceptions, the Wayfarer parties simply have no way of knowing exactly who took what steps as part of the conspiracy. But the Wayfarer parties know and allege that Sloan made statements to reporters referring to Baldoni as a sexual predator and accusing him of sexual assault. In addition, Sloan seeded false information about Baldoni to the Daily Mail in an effort to divert negative attention from Lively. The cases cited by the Sloan parties are either entirely inapplicable or materially distinguishable. And we're citing a case law here. Let's see. The question before the court was whether the allegations were specific enough. The Sloan parties do not contest personal jurisdiction, which is governed by an entirely different and far more fact-intensive legal standard. In Bordeaux, the lumping together of the defendants prevented an individualized analysis of whether the court could properly assert personal jurisdiction over each of them individually, while the court also dismissed the case on Rule 12b6 grounds. It was for failure to meet the heightened pleading standard for aiding and abetting and commercial bad faith, not failure to satisfy Rule 8. Okay. And I'm going to skip over this case stuff. To the extent there is a lack of differentiation in the First Amendment complaint, it does not rise nearly to that extreme. And he was citing some complaints up here that I'm sure some legal law troopers are going to go over. So the footnote here says the Wayfarer parties have since obtained additional information specific to the allegations against Sloan that they would add if the motion were granted with leave to amend. And I want to see that. So, like I said. All right. We're on page 24 of 55. We're almost halfway through. But I really do have to go to the bathroom. So what I'm going to do is I'm going to put on something funny for you guys, and I'm going to come back as soon as I can. It will take me like 5 minutes. I'm very sorry that I have to do this, but I didn't have anyone else who could help me out reading tonight, so I have to. I have something that you can watch, which will be mildly entertaining, if not very entertaining. So give me 1 second, and I'll pull it up, and I'll be back in 5 minutes. Okay. Gosh, I have to find it first. No, there it is. Now, let me know if you... Welcome back to the internet where your cesspool is my jacuzzi. My name is Neidigh, and I'm coming to you from Australia today. Before I got on my plane from San Francisco to Sydney, I said I had to blow dry my shoes. I couldn't explain myself because I knew I wouldn't do it justice unless I told the whole story. So here I am, checking in just to drop some knowledge. Someone just please tell me if you can hear this so I can go pee. God damn it. I was walking near the piers in San Francisco because I love doing those boats where you can like go around and see the city lights and stuff at night. Okay, you can hear the boat was leaving in 10 to 15 minutes, and I had a little bit of a walk. I had to rush over there, and as I'm walking towards the pier where the boat is, I see a crowd gathered. I'm not really sure why they were gathered there. I'm not sure what they were waiting for, but you can bet that if I see a crowd of people, or even a small group of people, I'm going to do whatever I can to dodge the people. So I'm looking around and then I see it. This is my escape plan. I do this all the time at home without thinking about it, and I decided to cut through some grass and go around the crowd. I get one step into this grass and regret fills me to my core. My carefree attitude towards this plan evacuated me like a fart would clear a crowded elevator. This was like every shortcut I have ever taken conspired against me to embarrass me and punish me in this moment. When I stepped in that grass, I had a Dorothy-like experience of we're not in Florida anymore. This grass was wet and muddy, like a swamp or a frat boy on Labor Day weekend. And it was cold. I knew right away there was nothing I could do. My whole body fell to the ground and I skid like a kid on a slip and slide. But that wasn't the only skid mark that day, because unfortunately I landed on my ass and I was wearing some thin yoga pants. My pants and shoes were covered in mud front and back, and my jacket was covered in mud on one side. Now, remember when I said I did all of this in front of a crowd that was waiting for something? Well, that crowd was right there, which is why I went to the grass in the first place. I'm not sure what they were waiting for, but suddenly it was me that they had been waiting for. Because every time I tried to get up, I just slipped in the mud and fell again at a different angle. It was like I was doing some sort of new age interpretive dance for them. I'm a dirty, dirty dancer. And the interpretation is help. Please save me from myself. A couple of police officers, after having a bit of a WTF moment, came over to try to help me up. It took 2 police officers to get me out of the mud. I seriously contemplated whether or not they should arrest me for being a public disturbance at that point. But what do you even say after something like that? So I had a boat to get to, and we all just kind of looked at each other for a second, and then I shuffled off as fast as I could to get out of eyeshot of anyone who just witnessed that. But I had a bigger problem. There was no way they were going to let me sit on that nice boat looking like a human skid mark, which, by the way, the pants I was wearing were unfortunately thin, like I said, so the mud had infiltrated my underwear, I was done for. I was like covered in mud. I was looking for a bathroom I could use to attempt to wipe some of the mud off of myself, and I kept seeing restrooms for customers only signs. And let me tell you, I took that personally. Someone from that crowd of people must have told all the establishments I was coming. At this point, I know it's hopeless to think I might be able to clean myself off. Our country has been in a state of deep division. But let me tell you, this transcends politics because both conservatives and liberals alike will agree that I was a walking disaster at that point. I start looking around at the touristy shops because I have to get pants, and pants that I can actually wear. I found one that sells pants, but remember that my underwear are also destroyed, so now I'm going to have to be going commando. Well, since I didn't want to be Commander Camel Toe, I had to find pants that fit. And there was only one that I found. It was a pair of prison-striped pants that said, "I just escaped from Alcatraz." And normally I would think those pants are cool, but no, because I looked the fucking part. Like I had just thrown myself into the bay and then soiled myself trying to climb out. But I bought the pants and I wandered over to the line to get on the boat where children pointed and stared, and I proceeded to explain myself to everyone who didn't even ask. Finally, I get on board where I can use the bathroom and I change into my new prisoner pants. And that's the story of how I ended up in front of Alcatraz with a pair of "I just escaped from Alcatraz" pants on. And let me tell you, my outfit did not pass the vibe check compared to the rest of the boat. And this was after I had wiped myself off a little bit, but I'm going to show you guys some pictures anyways. Those were my pants, and that's just the back of the pants, right? Like, it was pretty bad, and it was cold. It was so cold. Like I said, I fell on one side of my jacket, so you can't see the front of the jacket, which is also soiled, but here's the elbow of the jacket where I had fallen the first time. You can also see the tag on that jacket, and I had bought that jacket that day because, like I said, I came from Florida where it's warm, and I didn't think, hey, Lauren, you might want to bring a jacket to the pier. But it's okay, because I didn't really care for it that much anyways. This was my favorite pair of tennis shoes, and they were like covered in grass and mud, and my socks were so wet. It was disappointing, to say the least. And then you can see, of course, some of where the mud was on my pants in the front there. Here were the pants I had to put on. And there's me in my prison pants in front of Alcatraz. Now, the pants and the jacket, I just tossed them. But the shoes, like, I was like, no way I'm throwing away these shoes. So I gave them a little dunk in the bathtub, and I washed them off. I was able to get the mud off, but they were wet for days. And I was like, I have to dry these before I put them in my suitcase to go on a 16-hour flight, because if I don't, I feel like the rest of my clothes are going to get a little disgusting. So I sat there blow drying my shoes before I went to the airport. You would think that would be enough clown behavior for 1 week too, but no, because when I finally got to Sydney yesterday, I was so tired that I accidentally started washing my armpits with conditioner. I think that's all you guys need to know about that. Sorry, I had to take a quick break, but I am back now, so we can continue reading the document. Yeah, there was a lot of stuff going on that trip, and I'm going back to Australia in June, so I'm sure there'll be more shenanigans. I'm actually going to meet up with my friend Omar, the Tilted Lawyer in LA, on the way, and we're doing a charity race. So he and I are going to do a swimming race because I'm a former swimmer. I swam through collegiate years, and then so I'm good at swimming, but he's actually fit, and I'm like really out of shape, so I feel like it's even. And so we're going to do this race, and we'll video it and everything, where we're going to have our subscribers like do like a donation pledge so we can raise money for charities. And then whoever wins gets 60% for their charity, and whoever loses gets 40% for their charity. And then I was thinking I might do like the No More thing for mine, but then I also might do a different charity, so I'm not sure yet. I haven't picked one. Anyways, that's personal. I'll stop talking about me now. You've just heard my entire life story, basically, and that video was on my break. 1 second. Let me move this banner, and then we'll get going. Okay. Did we read this paragraph? I'm not sure. I'm going to start over anyways. I got my back off water. Hang on. Okay. If the court finds merit in the Sloan party's group pleading argument, it should note that the Wayfarer parties intend to move for leave to amend their pleading. The Wayfarer party's underlying allegations and claims are well grounded in fact and law, and defects of this kind are readily curable to the extent they exist. Under Rule 15 of the Federal Rules of Civil Procedure, the court should freely give leave to amend when justice so requires. In interpreting Rule 15, the Second Circuit has explained that the district court should not deny leave unless there is a substantial reason to do so, such as excessive delay, prejudice to the opposing party, or futility. See also Block versus First Blood Associates. Okay. B. California law, not New York law, applies to the Wayfarer party's claims against the Sloan parties. The Sloan parties claim that New York law, not California law, should apply to this case. But the weight of authority clearly demonstrates the appropriate law to apply in this case is the law of California. In diversity cases, federal courts apply the choice of law rules of the forum state. Okay. The choice of law rules of New York, therefore, apply to this case. The first step in that analysis is to determine whether exists a conflict between the laws of New York and California. Okay. And like I said, I'm going to skip over some of this case law stuff, guys. An actual conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of this case significantly. Here there exist substantive conflicts between the laws of New York and California as to each of the Wayfarer parties' claims against the Sloan parties for defamation, false light invasion of privacy, and civil extortion. As to false light invasion of privacy, the conflict between the two states' laws is total. California recognizes the claim, while New York does not. Okay. And if you don't know what false light invasion of privacy is, we're going to look that up real quick. Okay. A false light invasion of privacy is a legal claim where someone is portrayed publicly in a misleading or inaccurate way, creating a false impression about them that would be considered highly offensive to a reasonable person, essentially damaging their emotional well-being rather than their reputation in a defamation claim. Huh. Okay. So it's like you would offend someone in a way that, like, you portray them in a way that's going to cause them emotional distress rather than reputational harm. Interesting. It is considered one of the four main types of invasion of privacy torts under U.S. law. I didn't know that. Okay. Same is true for civil extortion claim. Moreover, although extortionate behavior, coercion, and duress may be elements of a cause of action for tortious interference with a contract or unjust enrichment, at common law, there was never a private cause of action for extortion. Okay. And then the footnote says the claim for false light invasion of privacy is personal to and brought by only Baldoni, Heath, Nathan, Abel, and Sarowitz, not by Wayfarer Studios or It Ends With Us movie. For simplicity's sake, this opposition refers to the claims collectively as being brought by the Wayfarer parties. Okay. Our Supreme Court has recognized a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution. They're citing a case here. Disapproved of on other grounds by Silberg v. Anderson. Okay. Like I said, guys, I'm going to skip through a lot of the case law stuff. Clearly, there is a total conflict between the laws of California and New York when it comes to these two claims, rendering a choice of law analysis necessary. There are also important differences between the laws of New York and California with respect to the Wayfarer party's defamation claim against the Sloan parties. For example, California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. Because there exists a substantive conflict between the laws of New York and California as to the Wayfarer party's claims for defamation, false light, and civil extortion, the court must analyze whether to apply New York or California laws to those claims. The choice of law must be analyzed individually as to each claim. Okay. We're going to skim over the case stuff here, guys. In defamation cases, New York applies the law of the state with the most significant interest in litigation. Okay. Under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case. Okay. And its law will therefore govern. Although the preference for the plaintiff's domicile is not conclusive, the significant contacts in a defamation case are almost exclusively the parties' domiciles and the locus of the tort. The interest of a state in a defamation action is significant and incontrovertible, where the plaintiffs are citizens of that state and live and conduct their business there. Though New York may have some interest in the Wayfarer parties' defamation claim against the Sloan parties, because the Sloan parties are residents of New York, California has a much more significant interest because nearly all of the plaintiffs are residents of California or have their principal place of business there. The two corporate plaintiffs, Wayfarer and It Ends With Us movie, are both incorporated and or have their principal place of business in California. The plaintiffs suffered injuries to their reputations in California. We had a footnote 5 here. It says the only plaintiff who is not a resident of California is Sarowitz, and we read that already. So, okay, the economic losses to the plaintiffs were all felt in California. Go to the bathroom. I already did that. One sec. Jasmia says, could you privately share the audio from earlier? I was at work and unable to listen. So I thought about sharing it on Patreon, but when I heard back from the courts, they were pretty clear they didn't want it posted anywhere. So I removed it. I apologized quickly, and I don't know if you guys saw that message I had sent them before. I was like, basically, hi, I've never done this before, and I was not in the beginning of the call, but then I heard later that you guys didn't want it recorded. They told me to take it down, please. They said they would appreciate it if I took it down. I did, and then I said, I'm sorry. Basically, it won't happen again. I've just never done this before, and I made a mistake. Nothing bad happened. I just, I don't want to then kind of exploit any loophole or anything like that, so I don't really want to put it back up, because this is like a legit court case, and the judge said not to. And once I got confirmation of that from the courts, I was like, oh, absolutely not. I don't want to, I don't want to violate any rules. You know what I mean? That's not my game. So yeah, I wish I could share it with you. I just can't. So I had to remove the stream, and unfortunately I can't, but I will be doing a recap stream talking about everything that was said kind of piece by piece tomorrow. So I just won't be able to share the audio. Okay. I think Neil said Patreon might be where you might be able to find it. I don't know. You can check. I'm just personally, I'm just not putting it there, just because I'm a very paranoid person when it comes to I don't want to get in trouble. I've been like that since I was a kid. I'm like, I don't even want to get in trouble for sniffing glue in class. I don't want to, so I will err on the side of caution. That's me. That's just me though. I don't know the laws, so I don't know the specific laws or anything like that. This was just my first time, and I messed up. So, all right. Let's see. We got through that. In addition, the underlying New York Times article, which is in many respects the genesis of this entire action, is purportedly based on reporting relating to Lively's complaint filed with CCRD, which purported to assert claims for violation of California's Fair Employment and Housing Act and Labor Code. That's a mouthful. The Sloan parties also gloss over the undeniable fact that the film's production, the purported site of the majority of Lively's unfounded allegations, took place not in New York, but in New Jersey. All right. We have a footnote 6 here. It says, the First Amendment complaint alleges Wayfarer also suffered injury in New York as well as in their home state of California, which is a true statement, notwithstanding the fact that the bulk of the harms were felt in California. To the extent that additional allegations are necessary to cure any inartful pleading as to the primary location of the harms, the court should grant leave to amend pursuant to the extremely liberal standard. We read that before up there. So, one sec. Sorry, guys. I just got to check one thing real quick. Yeah, I'm good. Okay. Sorry, I had a urgent email I had to scroll through. Anyways, Exhibit A at 51. Yet the Sloan parties have not proposed that New Jersey law. Okay, so let's roll that back. So the Sloan parties gloss over the undeniable fact that the film's production, the purported site of the majority of Lively's unfounded allegations, took place not in New York, but in New Jersey. Okay. First Amendment complaints, and that is in paragraph. It cut off there, but it says exhibit. Oh, it's the timeline, Exhibit A at 51. Yet the Sloan parties have not proposed that New Jersey law should apply to this action. My bad, guys. In short, the laws of California can and should supply a remedy for the harms felt primarily in California by plaintiffs who all live, work, and or do business in California as the result of conduct aimed at California. Okay. C, the FAC states a claim for defamation against the Sloan parties. Regardless of which state's law applies, the Wayfarer parties have pled a legally sufficient defamation claim against the Sloan parties. Under California law, defamation is an invasion of the interest in reputation. The tort involves the intentional publication of a statement of fact that is false, unprivileged, and has a natural tendency to injure or which causes special damage. Defamation may consist of either libel or slander. Libel, which is an issue here, is defined as a false and unprivileged publication by writing, printing, picture, effigy, or other fixed representation to the eye, which exposes any person to hatred, contempt, ridicule, or what is that word? Obloquy? Obloquy? I don't know how to say that word. I need to know, though. Hang on. Give me a sec. What? Strong public criticism is what this word means. Pronunciation. Obloquy. 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 Okay, I got it now. Sorry, guys. I'm trying not to be a dumbass, but I have to learn as I go. Obloquy, or which causes him to be shunned or avoided, or which has a tendency to injure him in his occupation. Where the defamation is clear without the need for any explanation, it is considered defamation per se, and damages are presumed. Where the defamation is not per se, and some explanation is needed to show why the statement was defamatory, the plaintiff is required to allege and prove that he or she suffered special damages such as harm to reputation, shame, or economic damages. Is this new? What is this? Hi, Reg Angel. Yes, this is very new. It came out not that long ago. Maybe an hour ago? When did I start the stream? An hour and a half ago. Yeah, it came out an hour and a half ago. It's the response to Leslie Sloan and Vision PR's motion to dismiss. Baldoni and the Wayfarer parties have responded in opposition. So. Rainbow Pickle says, I know Dave said he will do puppet play or something to tell what's said. I would tune in for that. Let's see. Oh, let me close that real quick. I'm just going to open these super chats. Kai says the precursor had to be way before December 20th. It actually wasn't. It actually wasn't. And if you remind me, I'll pull that up on the stream before we end so we can speculate on that. But I looked at it yesterday. BL's team outed themselves with Friedman's subpoena on BL's security team. We would have never known. Yeah. I think I might have read that one earlier. Go pee and play an LO trial video. I didn't think of that, but I probably should have. So Kai, remind me towards the end of the stream, and we'll get into that, because the precursor, I can show you when it was filed, and I can show you what it says and all that. But I want to get through the rest of this document first, because this is the breaking news or whatever. So, All right. Where the defamation is clear without the need for any explanation, it's considered defamation per se, and damages are presumed. Okay, they're citing case there. Where the defamation is not per se, and some explanation is needed to show why the statement was defamatory, the plaintiff is required to allege and prove that he or she suffered special damages, such as harm to reputation, shame, or economic damages. To state a claim for libel per se under New York law, a plaintiff must allege 1. A written defamatory statement of fact concerning the plaintiff. 2. Publication to a third party. 3. Fault, either negligence or actual malice, depending on the status of the liable party. 4. Falsity of the defamatory statement. And 5. Special damages or per se actionability. There is no question that, under the laws of both California and New York, the Wayfarer parties state a plausible claim for defamation per se. There's a footnote. Let's read that. The Sloan parties attempt to invoke the fair report privilege under New York civil rights law. It's unavailing. The purpose of Section 74 is to avoid stifling an active, thriving, and untrammeled press, and to ensure that the press receive broad protection. Not only are the Sloan parties not members of the press, the FIC alleges they were responsible for feeding the defamatory information at issue to the press. Furthermore, the statute may not be invoked where a party maliciously institutes a judicial proceeding alleging false and defamatory charges as a vehicle to publish and disseminate those charges. Okay. See, the Sloan parties made defamatory statements of and concerning the Wayfarer parties. As to Baldoni, the FIC alleges that Sloan parties made one or more statements to third parties, including without limitation to the New York Times and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The complaint alleges that Sloan parties made further false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production. The means by which she did so, for example, false accusations of sexual misconduct, and the resulting turmoil. Specifically, the Sloan parties stated to the Daily Mail, among others, that reports of a power struggle on set were 100% untrue. Your info is totally off. You have it all wrong. Your reporters are so wrong. Instead, the Sloan parties seeded false information to cast Baldoni rather than Lively in a false light. The whole cast doesn't like Justin, nothing to do with Blake. They are panicking as the whole cast hates him. As to the other Wayfarer parties, the First Amendment complaint alleges that the Sloan parties made one or more statements to third parties, including without limitation to the New York Times and other news outlets, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and retaliated against Lively for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Can we get back to the plowing that was in the first paragraph? Not gonna lie, that was the best part. All right. Let's see. Pinahon is shrill her voice. It's sad that some women's voices are irritating to listen to. Hey, man, I mean, some men's voices are irritating to listen to. I'm assuming we're talking about the lawyer for the Sloan parties that we heard earlier today, in which case she was absolutely shrill. Yeah. I remember, like, anytime she would come up, because I had the phone sitting right here next to the mic, and I had to lift it up when she was talking and literally turn my volume down. And I was just like, I'm so sorry. And I remember at one point, I know the video was removed. At one point, I told people in the chat, like this video or I'm turning her back up. That's how bad it was. Anyways, let's keep reading. One sec, guys. I want to do one thing here. There's something from Kai I wanted to read, but I can't find Kai. I don't know if she's still here or not. Anyways, oh, I forgot to hydrate on mute. I'm sorry. As alleged in the First Amendment complaint, the Sloan parties told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints with the knowledge and intent that the newspaper would publish the false story. The Sloan parties propounded, a false smear campaign narrative designed to destroy the Wayfarer parties. Okay. The Sloan parties contend that the FAC fails to allege that the Sloan parties made defamatory statements of and concerning the Wayfarer parties other than Baldoni. A statement upon which a defamation claim is based must specifically refer to or be of and concerning the plaintiff in some way. Okay, we're skipping over the case stuff. There is no question. Whoa, sorry, I hit a button. There is no question that the requirement is satisfied here. As alleged in the complaint, all of the Wayfarer parties, including those without a public profile, have become figures of infamy and derision as a result of the Sloan party's defamatory statements, which were widely disseminated and universally understood to refer to them. Furthermore, the of and concerning requirement is generally an issue of fact for the jury to decide, and the court may properly dismiss an action only where the libelous statement is incapable of supporting a jury's finding that it refers to the plaintiff. Okay. Oh, the Church of Scientology is cited again. Anyways, this is not a situation in which a jury would be incapable of finding that the statements at issue refer to each of the Wayfarer parties. Any doubts raise a question of fact for the jury and not a question of law for the court. And the Wayfarer party's allegations implicate the small group exception of the group libel doctrine. Under the group libel doctrine, typically a statement made about an organization is not understood to refer to any of its individual members unless that person is distinguished from other members of the group. But where a statement defames all members of a small group, the reference to the individual plaintiff reasonably follows from the statement. Accordingly, an individual belonging to a small group may maintain an action for individual injury resulting from a defamatory comment about the group by showing that he is a member of the group. Okay. Give me 1 second to hydrate, guys. I gotta hydrate on mute as my commenters have requested. All right, I've come back to life. Sorry about that. Okay. The Sloan party's statements are not an actionable opinion. The Sloan parties further contend that defamatory statements attributed to them constitute an actionable opinion. They are wrong. Under California law, in order to constitute actionable defamation, the offensive publication must consist of statements of fact rather than opinion. A statement can be defamatory only if it's capable of being proved as true or false. Statements do not imply a provably false factual assertion and thus cannot form the basis of a defamation action if they cannot reasonably be interpreted as stating actual facts about an individual. KKB, thank you for the 10. Ari Emanuel is Sloan's husband. Is that true? He was the one who was leaked saying JB, BL, and RR were all his clients, and he dropped JB based on the article and filing, which we know that isn't how that went. Thank you for the 10. I know who Ari Emanuel is, and I streamed about that that recording, which was leaked by the Colonel Kurtz and also Citizen Journalist. But they're married? Hold on. Wait. This says he's married to someone named Sarah Steininger. Yeah. So that doesn't make sense to me. I'm confused. How he's going to testify? I don't know. They are definitely married. Are you sure? Because hang on, let me show you guys. I'm looking at the right ARIA manual, right? Here's Wikipedia. It says spouses Sarah Hardwick Addington, divorced in 2018, and current spouses Sarah Staudinger. All right, who are you? Let's see who she is. American fashion designer. Okay. Occupation fashion designer. I don't think so. I was about to say. Chat, don't troll Lauren. She's a nice lady. Honestly, dude, troll me. It's fine. I don't mind. It does stuff for my algorithm, and also, like I said, I'm gonna do a show later where I respond to mean comments, so it doesn't matter. But if you're doing super chats, please don't troll me, because then it throws off the entire stream, because I have to pay attention to your super chats. Joan's husband is a partner at WME. That's different. Okay, that's different. I thought she was related to, the agent or whatever. Anyways, back on track here, guys. Let's get back on track here. Oh, sorry. I accidentally switched the tab. This was what I was looking at earlier. Here we go. That was the court listener website, because I was trying to get it for free, but they didn't have it up there yet. So, one second. I'm double checking just to make sure. It's been a couple hours, so I was double checking just to make sure nothing else was filed since we started this stream. All right. Anyways. Under California law, in order to constitute actionable defamation, the offensive publication must consist of statements of fact rather than opinion. A statement can be defamatory only if it's capable of being proved as true or false. Statements do not imply a provably false factual assertion and thus cannot form the basis of a defamation action if they cannot reasonably be interpreted as stating actual facts about an individual. Thus, rhetorical hyperbole, vigorous epithets, lusty and imaginative expressions of contempt. What the fuck? What you guys are doing in these courtrooms? And language used in a loose, figurative sense have all been accorded constitutional protection. Good to know. But apparent expressions of opinion often imply an assertion of fact and are therefore actionable. Weller v. American Broadcasting says, thus, a statement in the form of an opinion may be actionable if it is implied that it is based on some undisclosed defamatory facts. The issue of whether the statement is fact or opinion is one for the jury. As for the court, the dispositive question is whether a reasonable fact finder could conclude that the published statements imply a provably false assertion of fact. All right. To answer that question, the court applies a totality of the circumstances test pursuant to which the court reviews the language of the statement and the context in which the statement was made. If a statement is factually specific, earnest, or serious in tone, or the speaker represents himself as unbiased, having specialized or first-hand experience, or having personally witnessed abhorrent behavior, this may signal that there is a factual basis for the accusations and render the statement actionable. Okay. Whether a challenge statement declares or implies a provable false assertion of fact is a question of law for the court to decide, unless the statement is susceptible of both an innocent and a libelous meaning, in which case, the jury must decide how statement was understood. Courts applying New York law generally consider 1. Whether specific language in the issue has precise meaning which is readily understood. 2. Whether the statements are capable of being proven true or false. And 3. Whether the exit, or whether either, I don't know where I got that from, whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. The analysis is not rigid. A court must have the flexibility to consider the relevant factors and to accord each the degree of importance which the specific circumstances warrant. The Court of Appeals in New York has consistently focused its analysis on the overall context in which the complained of assertions were made. Context includes not only the immediate context in which the disputed words appear, but also the larger context in which the statements were published, including the nature of the particular forum. KKB, thank you for the 5. Sorry. I heard wrong. Her husband is high up in that group, though. Okay, no problem. It's no problem. I just had to look it up, that's all. Thank you, guys. Codename Plow! Oh, God. I missed page 2. Is that where the plow statement was? Because I really liked how this started out. Now I'm kind of tired. But yeah, we're gonna keep going. We're gonna power through the rest of this. We're gonna plow through the rest of this chat. How about it? How do we feel about that? Hold on. Oh, look at that. Court listener finally got a document. Okay. Okay. Anyways. The analysis is not rigid. A court must have flexibility. I think we went through that. If a statement is found to contain opinion, that is not the end of the inquiry. The court must then examine whether the statement is pure opinion and thus not actionable, or mixed opinion and therefore actionable. The actionable element of a mixed opinion is not the false opinion itself. It is the implication that the speaker knows certain facts unknown to his audience, which support his opinion and are detrimental to the person about whom he is speaking. The dispositive inquiry is whether a reasonable reader could have concluded that the statements were conveying facts about the plaintiff. Okay. Here, the alleged statements are either direct statements of fact or statements that imply the existence of undisclosed facts. All are susceptible to defamatory meaning, notwithstanding the Sloan party's bizarre argument to the contrary. It is clearly a statement of fact to accuse someone of having committed sexual assault. Sexual assault accusation readily perceivable as allegations of facts susceptible to proof of or disproof of falsity. The statement referring to Baldoni as a sexual predator also cannot reasonably be construed as an expression of pure opinion. At minimum, it implies a provably false assertion of fact and lends itself to a defamatory meaning. As alleged in the first amended complaint, it was intended to convey that Baldoni had committed sexual assault. The Sloan party's other statements about Baldoni are similarly libelous. Publishing the statements to a reporter that the whole cast doesn't like Justin, nothing to do with Blake, and the Wayfarer parties are panicking as the whole cast hates him, were clearly and inarguably intended to convey undisclosed facts of a defamatory nature. As alleged in the complaint, it is false that any issues between Baldoni and the cast, especially in retaliation to the promotion of the film, had nothing to do with Lively. A reasonable reader would, and the Daily Mail reporter did, interpret Sloan's statements to mean that Baldoni had engaged in misconduct or had otherwise, through his own actions, caused them to turn against him. But that is neither what happened nor what is alleged in the first amended complaint. Indeed, the Wayfarer parties allege that Lively induced the other cast members to shun Baldoni in an early attempt to give fans the impression that Baldoni had committed an egregious sin, something so egregious that no one wanted to even take photos with him or have him around. Prior to Lively's inducements, these same cast members showered warm praise and appreciation on Baldoni. One female cast member, prior to Lively's inducements, exchanged grateful texts with Baldoni during and after her filming stint. That has to be Isabella Ferrer, right? Which included a number of scenes involving intimacy. That had to be Isabella Ferrer, I think. The actress worked with Baldoni when Lively was not on set. It was not until she spent substantial time with Lively during film promotions that she felt compelled to shun Baldoni in repudiation of her warm words. The Sloan party's statements about the rest of the Wayfarer parties are likewise false statements of fact. Specifically, the Sloan parties made statements that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and orchestrated a smear campaign and retaliation for Lively's purportedly protected disclosure of such conduct. The allegations in the complaint are unequivocal. None of the Wayfarer parties engaged in any kind of misconduct towards Lively. The Wayfarer parties did not permit or fail to prevent such misconduct, and the Wayfarer parties did not orchestrate a smear campaign in retaliation for Lively's purported disclosures. As alleged in the FAC, the tidal wave of negative publicity that Lively confronted in August 2024 was the unsurprising result of tone-deaf marketing, off-putting public appearances, and the excavation by internet sleuths of unflattering prior interviews. The Sloan party's statements imply that the Wayfarer parties engage in grossly immoral conduct to cover up even more grossly immoral conduct. And such statements resulted in the destruction of their reputations and careers, among other cataclysmic consequences. The statements cannot be, and were not, construed as mere statements of opinion or of hyperbole. They were statements of fact, and they were false. And if a court concludes that the statement could be reasonably construed as either fact or opinion, the issue should be resolved by a jury. I agree. In either event, the motion should be denied in this respect. Oh my God, we're only on number 3 here. Don't worry, guys. We have less than 20 pages left, I swear. No worries, no worries. Give me 1 second to hydrate on mute. No, Isabel, not you. Unless it was you, in which case. Just kidding. All right. God, I miss sleep. Let's go, guys. All 811 of you are what's keeping me awake right now. I'm going to put it that way. It's making it worth my time. The Sloan party's statements are not substantially true. The Sloan parties also urged the court to dismiss the Wayfarer party's defamation claim on the grounds that alleged statements are substantially true. Like I said, we're going to skim over the case law stuff a little bit. However, truth is a question of fact for the jury. The only exception when substantial truth is evident to the court is not remotely the case here. Wait, they're citing DARE America? That's still a thing? Taking the allegations in the FAC as true, as the court must on a rule 12b6 motion, the court simply cannot conclude as a matter of law that 1, Baldoni sexually assaulted Lively, 2, Baldoni is a sexual predator, 3, Lively had nothing to do with the cast's alienation from Baldoni during the promotion of the film, 4, the Wayfarer parties orchestrated a smear campaign in retaliation for Lively's purported disclosure that she had been sexually harassed. All of these propositions are expressly denied by the Wayfarer parties in the complaint, and there is extensive elaboration on the bases for their denials. The Sloan party statements clearly have a different effect on the mind of the reader from that which the pleaded truth would have produced. However, this case does not present a question of slight inaccuracies of expression, but rather of fundamentally different realities. I like that. All right. While the Sloan parties appeal to Lively's allegations or pleading, those allegations are not properly before the court on this motion. The Wayfarer parties adamantly deny the veracity of the Sloan parties' accusations in their First Amendment complaint, not on technical or marginal grounds, but rather as flatly false. The court is in no position to rule that the statements are substantially true based on the Wayfarer parties' pleadings. A jury must ultimately decide truth or falsity. I'm sure my parties never should have been dragged into this is going to be thrilled when she reads that. 4. The alleged statements concerning sexual assault are sufficiently specific. The Sloan parties also contend that statements concerning sexual assault are insufficiently specific to defend against. That is in spite of the fact that, in the same motion, they also contend that the statements are an actionable opinion and or substantially true. The federal rules require that each pleading be specific enough to afford the defendant sufficient notice of the communications complained of to enable him to defend himself. The defamation case cited by the Sloan parties and dismissed by this honorable court involved allegations so threadbare as to be irrelevant here. And that reminds me of this honorable court. I don't know, like at some points today, it would be really funny when the lawyers would say like, as your honor, or like they would just refer to the judge as honor, like whatever. And I know that's proper decorum in a court, but just hearing it like from my attic, just hearing that from my attic, I was just like, wow, that's that's so much. All right. Let's skip over this case law. The Sloan parties also appear to confuse the applicable pleading standard. A plaintiff asserting a state law defamation claim in federal court need only satisfy Rule 8. A state's heightened pleading requirement, such New York's, does not apply. Okay. Said we're going to skim over this gay stuff. It sounded like I said gay stuff. I said case stuff. I never skim over the gay stuff. The Wayfarer parties have met their met their pleading burden under Rule 8, even as the contours of the conspiracy will further come into focus through discovery. Number 5, the Wayfarer parties need not plead special damages because the Sloan party statements are defamatory per se. The Sloan party's argument that the Wayfarer party's defamation claim fails for failure to plead special damages is unavailing because plaintiffs need not plead such damages where, as here, the alleged statements are libelous per se. California law recognizes 2 types of libel per se and libel per quad. A statement constitutes libel per se when it is defamatory of the plaintiff without the necessity of explanatory matter, such as inducement, innuendo, or other extrinsic fact. And they're citing a case here. The same is true under New York law. A statement is actionable without alleging special damages if it tends to expose the plaintiff to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of him in the minds of right-thinking persons and deprive him of their friendly intercourse in society. All of the Sloan party's alleged statements are defamatory per se. As to the statements concerning Baldoni being a sexual predator who committed sexual assault, there is no question these are defamatory per se. Perhaps the clearest example of libel per se is an accusation of crime. Sexual assault is obviously a crime, and referring to someone as a sexual predator is intended to, and does, convey an impression of criminality and malice. The statements concerning the rest of the cast hating Baldoni conveys an impression of some undisclosed egregious sin, something so egregious that no one wanted to even take photos with him or have him around. With respect to the other Wayfarer parties, there is similarly no question that the statements are at issue or defamatory per se. The crux of the accusations is that the Wayfarer parties engaged in and or condoned sexual misconduct and took revenge on the victim of such misconduct through a scorched earth public relations vendetta. These allegations tend to expose the Wayfarer parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them in the minds of right-thinking persons, and to deprive them of friendly intercourse in society. As to it ends with us and Wayfarer, it is well settled that a statement that impugns the basic integrity of a business is per se defamatory. Those are exceedingly serious accusations that tend to subject and already have subjected the Wayfarer parties to reputational collapse and public derision. On the face of these allegations, the pleading of special damages is unnecessary. 6. The Wayfarer parties have pleaded actual malice. Whew. Give me a second, guys. This is wordy. This is wordy, and I need some water. All right. The Sloan parties further contend the Wayfarer party's defamation claim fails for the failure to plead the requisite state of mind. Specifically, they argue that Baldoni is a public figure and thus cannot state a claim for defamation without plausibly alleging that the Sloan parties made the alleged statements with actual malice. This argument fails for 2 reasons. First, as to Baldoni, the Wayfarer parties have unequivocally pled facts sufficient to infer actual malice. Second, the other Wayfarer parties are not public figures, and therefore pleading actual malice is not required to state a claim for defamation. For the purposes of this motion alone, the Wayfarer parties presume the application of the actual malice standard and submit its pleading burden has been satisfied. As a matter of constitutional law, if the person defamed is a public figure, he must prove by clear and convincing evidence that the statement at issue was made with actual malice, with knowledge that it was false, or with reckless disregard of whether it was false or not. The Supreme Court has explained that while the concept of reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity, or must have entertained serious doubts as to the truth of his publication. And footnote 8 here says, in the event the court determines that any of the foregoing are not in fact defamatory per se, the Wayfarer parties respectfully request the opportunity to amend their pleading so as to allege special damages. Okay. The complaint is replete with allegations that the Sloan parties made the alleged defamatory statements with knowledge of their falsity or reckless disregard for their truth or falsity. The Sloan parties knew that Baldoni had not sexually assaulted Lively because Lively herself did not allege that Baldoni sexually assaulted her. Indeed, in her communications with a Daily Mail reporter in August 2024, Sloan affirmed, falsely in fact, that the issues on set had nothing to do with Lively. If Sloan believed that Baldoni had sexually assaulted Lively, that obviously would not be the case. The Wayfarer parties allege that the Sloan parties and their co-conspirators exaggerated benign interactions on set to concoct a false narrative that Lively had been sexually harassed. They did so, per the FAC, so that Lively could instill terror in the Wayfarer parties and leverage it to accumulate power over the production. This accumulation of power, akin to a hostile takeover, depended upon the ability to conjure ruinous allegations. They were never true, and the Sloan parties knew full well they were never true. The depravity of their plan, which the complaint alleges they carried out, clearly constitutes actual malice. Moreover, the Sloan parties admittedly hand in their possession materials which prove the falsity of their assertions concerning a smear campaign. Indeed, the day of Abel's termination, August 21st, 2024, Sloan called Nathan and gloated that she had Nathan's communications with Abel. Okay. If that were so, Sloan would clearly have known that the narrative advanced by the Lively parties and Sloan parties was false. Specifically, the Wayfarer parties had not engaged in a smear campaign or done any of the acts attributed to them by the Sloan parties. By way of example, while the Sloan parties provided the New York Times with text messages concerning purported allegations of sexual misconduct, she and her co-conspirators apparently omitted the subsequent message that the allegations were not true. And as for the untraceable smear campaign, it would have been clear to the Sloan party's public relations professionals that the cause of Lively's bad press was her decision to hawk liquor and hair care products while promoting a film about domestic violence. The notion that the backlash was actually caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. There were obvious reasons to doubt the veracity of these statements, which the Sloan parties disregarded. Taken as a whole, the complaint alleges sufficient facts to infer actual malice on the part of the Sloan parties and the other defendants. Finally, while the First Amendment complaint satisfies the Wayfarer party's pleading burden under an actual malice standard, it is important to note that 6 of the 7 Wayfarer parties are almost certainly not public figures. For example, Heath, Sarwitz, Abel, Nathan, it ends with us, and Wayfarer. The mere involvement of a person in a matter which the media deem to be of interest to the public does not, in and of itself, require that such a person become a public figure for the purpose of a subsequent libel action. Oh, they're citing Reader's Digest. In any event, because the FAC satisfies the much higher burden of pleading actual malice as to all of the Wayfarer parties, it is unnecessary to separately analyze the lesser standards. Damn. I bet the judge's curiosity to speak like all of us. Yeah. Damn. Oh, SD Johnson, how you doing? I haven't seen you in a minute. All right. D, the Wayfarer parties have adequately pleaded a claim for civil extortion, and we're on the last, we got single-digit pages left, guys. We're on 46 out of 55. And I'm assuming the last page or two is just signatures, so. We're getting there. As set forth above, supersection 4B, the proper law to apply in this case generally is the law of California. Here, the harm was particularly felt in the state of California, which is where nearly all of the Wayfarer parties are domiciled and where the international film industry is focused. Under that law, the Wayfarer parties have plainly stated a claim for civil extortion against the Sloan parties. The Sloan parties attempt to argue that the extortion claim is duplicative of the defamation claim because of the threats by which Wayfarer parties were extorted involved spreading lies that the Wayfarer parties engaged in sexual misconduct. But the very criminal statute on which California's civil claim for extortion is based specifies that fear, such as will constitute extortion, may be induced by a threat of any of the following: to accuse the individual threatened or a relative of his or hers or a member of his or her family of a crime; 3, to expose or to impute him, her, or them a defamatory, disgrace, or crime. Okay. To expose a secret affecting him, her, or them. Notably, extortion lies whether these statements, which facially resemble the grounds for a defamation claim, are false or true. Oh no, I'm wearing these again. It's too hot for that. Oh, I think I missed one here. KKB, thank you for the 20. To be fair, Sloan turned over text that had the full context. If she gave that to Blake, who gave that to New York Times, then they are all screwed, because in those thousands of docs and texts, Megan Toby had both sides all along. The cunts. Yeah, I think that's probably what happened. But yeah, thanks. Thank you for the 20. I appreciate you. You've been spoiling me today. I noticed. All right. Did we get to the bottom of this paragraph? I can't remember. I think we did. Furthermore, a claim for extortion does not require that the threat actually be carried out. Yeah, okay. The facts sufficient to state a claim, such as unconsummated threat to accuse a person, whether true or false, are in some ways the inverse of a claim for defamation, which requires the actual, not merely threatened, disclosure of factually false accusations. These diametrically opposed elements cannot logically give rise to duplicative claims. The Sloan parties further claim that they cannot have engaged in extortion because they did not obtain property from the Wayfarer parties by means of threats. This is false. California law proscribes extortion, notwithstanding that the defendant ultimately obtained no money or property by means of his extortionate threats. To the extent that the court determines that the Wayfarer party's factual allegations do not satisfy the TI pleading standard, the Wayfarer parties are armed with additional facts that they will set forth should the court grant them leave to amend. As an example, the Wayfarer parties are reliably informed and believe that the Sloan parties deliberately carried out the very threats that Lively used to extort control of the film. Upon information and belief, the Sloan parties widely disseminated false allegations that the Wayfarer parties had engaged in or covered up sexual misconduct, just as Lively threatened she would do. Actually carrying out an extortionate threat does not eliminate liability for extortion. I'll skim over the case law stuff here. The Wayfarer parties are reliably informed that these communications began well before the premiere of the film and the sudden downturn of Lively's public perception, and allege that the Sloan parties did so in order to keep the Wayfarer parties in line by instilling fear of Lively's threatened retribution. Under California law, a threat of harm by third parties constitutes extortion. By playing the role of the heavy and carrying out Lively's extortionate threats, the Sloan parties took an inexcusable part in Lively's scheme and are therefore liable for civil extortion by conspiracy. The First Amendment complaint states a claim for civil extortion against the Sloan parties, and the motion should be denied, or at most granted with leave to amend. E. The Wayfarer parties have adequately pleaded for a claim for false light invasion of privacy. For all the reasons set forth above, the law of California must apply to the Wayfarer parties' claim for false light invasion of privacy, while the Sloan parties argue that courts of this district have applied New York law to false light claims brought in New York. Those cases are distinguishable. I'll skip over the case law stuff. Whereas here, the Wayfarer parties were made defendants before they filed their claims in the same courts. Okay. Here, the only substantial tie to New York is that before the court is the fact that the Sloan parties reside in New York. That is insufficient to overcome California's strong interest in this action, given that 6 of the 7 Wayfarer parties reside in California, and the 7th is a resident of Illinois, not New York, who is linked to this action through his interest in Wayfarer. That the corporate entity plaintiffs are incorporated and or have the principal place of business in California, and that the Wayfarer parties suffered the reputational harms and economic losses at issue primarily within the state of California. Under California law, the false light claim is not duplicative of the defamation claim. The cases that the Sloan parties cite for this proposition are inapposite. Okay. Just give me over case law stuff. Furthermore, California courts do not dismiss false light claims as duplicative of defamation claims, but determine whether a false light claim stands or falls based on whether it meets the same requirements as a defamation cause of action. Okay. Any overlap in the allegations underlining the claims for false light and defamation is not, as the Sloan parties urge, a reason to dismiss the false light claim as duplicative. Rather, it simply means that the two claims will likely rise or fall together. Okay. Oh. Now one more text me back. All right. As with the defamation claim, to the extent that there exist any defects in the Wayfarer parties' allegations as to the nature of the statements made by the Sloan parties to others, the defects can readily be cured by an amendment. For example, the Wayfarer parties are reliably informed and believe and based and based thereon, and based thereon can allege that the Sloan parties engaged in a protracted campaign by which they contacted multiple reporters, including but not only the New York Times, to spread highly offensive falsehoods and misleading information relating not just to Baldoni, but to each of the Wayfarer parties, and they did so in conspiracy with each of the other defendants. Of course, because the Sloan party's conspiracy was secretive and carefully concealed, the evidence must necessarily emerge through the discovery process, which the Wayfarer parties have already begun. In the meantime, and consistent with Rule 1582's extremely liberal standard for amendments, the court should grant leave to amend to the extent it is not inclined to deny the motion in its entirety. Thank you, Lisa. I appreciate that. Oh, is Omar in here? Lauren, I can't help till 9:30. Dude, that's like, oh, there you are.
Hey, Lauren, I just want you to hear all the commotion that's going on right now, which is the reason why I said that. But I'm here for you anyway.
Oh, yeah, no problem, man. That's okay. No worries. I just wanted you to know you were invited.
Oh,
Yeah.
well,
I'm
I
not
felt
gonna.
obliged to make an appearance with all of my little shits running around.
Oh, yeah,
There's
no,
a,
I
a
appreciate that. That's
there's a
great.
bubble machine going on. There's a Laker game in the background. My daughter's giving me like teenager vibes. The wife is mad
Wow.
dogging me because I'm on the thing with you. She's like, you spend more time with the YouTube friends than you spend with me. I'm like,
But
hey,
just tell her I'm a gay and you're fine. So
oh, she knows.
okay. Oh yeah, of course she does.
With you, it's acceptable.
hmm Well, tell her I said hi.
Oh,
And
well, you just told
I'm
her.
not gonna make it till 12:30. But this document like just came out. If you want to read it on your stream, so
Yeah, I don't think I'm gonna read it word for word. I'm just gonna hit the highlights. I'm gonna do some legal analysis
yeah, I'm kind of
later.
regretting reading this word for word right now, but I'm almost done. So
Yeah, you got to pick and choose your battles, man. This is not one.
no, they're all my
No,
battles. They are all my battles, and I will march into them as soon as possible. So,
I'm also doing a bonus episode of Flat tonight. You're invited for that. You know what?
tonight,
Take all
are
the
you
gummies.
insane?
Yes.
Do you mean tomorrow?
No. I'm doing one tomorrow, but I'm doing a bonus one tonight, like an impromptu short version of
At
it
what?
tonight.
At what time? Jesus
Oh, it's
Christ.
gonna be late. I'm testing the after dark concept, and I'm testing different time slots.
All right. Well, just text me and we'll see if I'm awake. Let's put it that way.
We'll see. We'll see.
I'm
The
not
after
gonna
dark
try to
portion.
stay up for this one.
Don't even worry about it if you can. I will do it by myself. Maybe I'll get Bruce in there. It's completely, totally last minute.
But I miss Bruce.
Yeah, but I said, you know what? I'm gonna do a flat tonight. How about that? And so now it is so.
Yeah.
Vacation here is
There's a
because
small child on this stream.
we want to be on vacation here.
She's telling me where she wants to go on vacation.
Where do you want to go on vacation?
Where do you want to go on vacation?
Wait,
On a cruise ship.
On what kind of cruise ship?
I need to ask her a question.
A really
Come on.
fun cruise ship. First we got on an airplane, then take us to a cruise ship.
Oh, yeah.
Yeah.
You're more
Which
shrill
one?
than the lady from court earlier. Anyways, I gotta ask her a question, Omar. I need to know who does she think is gonna win a race, you or me?
Hey, I think was that an effective form of birth control? That right there. Imagine that
Ah,
24/7.
Yeah, I was totally pregnant before, but now I'm not. So
Lauren, I gotta go, man. It's like a circus over here.
you ask her that question and tell me the answer. All right, bye.
All right, up for sure. Bye bye.
Bye. All right. Nobody tell Omar I forgot his kids' names. Anyways, for example, the Wayfarer parties are reliably informed and believed based thereon. Okay, we went through that. Showing the level standard. We were like right at the bottom of this page. Even if the motion were granted without leave to amend, attorney's fees are not available to the Sloan parties under Second Circuit law. As set forth above, the court should deny the motion in its entirety or in the alternative, grant the Wayfarer parties leave to amend. But even in the extremely unlikely event that the court grants the motion in its entirety without leave to amend, if they did, because obviously they're a women-owned business, which, as they said 40,000 times, is just extremely important here. Anyways, but even in the extremely unlikely event that the court grants the motion, the Sloan party still would not be entitled to any recovery of attorney's fees in connection with their motion because the Second Circuit does not permit the application of state anti-SLAPP laws when they conflict with federal rules of civil procedure. As an initial matter, the Second Circuit has squarely held that California's anti-SLAPP law is inapplicable in federal court because it conflicts with Rules 12 and 56 of the Federal Rules of Civil Procedure. A state law conflicts with the federal rules of civil procedure when it answers the same question as one of the federal rules. California's anti-SLAPP statute creates a special motion to strike that requires outright dismissal unless the plaintiff can establish a probability that he or she will prevail on the claim. The statute thus establishes the circumstances under which a court must dismiss a plaintiff's claim before trial, a question that is already answered differently by Federal Rules 12 and 56. All right. Similarly, Rule 56 of the Federal Rules of Civil Procedure permits summary judgment only if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. Where Rule 56 allows a plaintiff to proceed at trial by identifying any genuine dispute of material facts, California's anti-SLAPP statute nullifies that entitlement by requiring the plaintiff to prove that it is likely and not merely possible that a reasonable jury would find in his favor. Accordingly, as the Second Circuit has expressly held, California's anti-SLAPP statute cannot apply in federal court. The Second Circuit has not yet directly addressed the question of whether New York's anti-SLAPP law applies in federal court. Still, federal district courts in the Second Circuit, including courts in this district, overwhelmingly agree that the holding of a la liberté similarly precludes the application in a federal court of New York's anti-SLAPP law, which, like California's, creates a special procedure mechanism through which defendants can invoke the anti-SLAPP law in a motion to dismiss. Okay. Other courts, such as this honorable court, have analyzed New York's anti-SLAPP law fee-shifting provision as a sanction that conflicts with Rule 11 of the Federal Rules of Civil Procedure. As noted in Brady, Rule 11 permits a court to impose sanctions only after the adverse party has been given notice and a reasonable opportunity to respond. New York's anti-SLAPP provision has no such requirement. A party may seek sanctions without providing any advance notice to the adverse party. The sole federal decision on which the Sloan parties can rely in support of their argument for an award of attorney's fees in the event of dismissal without leave to amend is Bobulinski versus Tarlov. And I'm just going to skim past the case law stuff, guys. One second, and take a sip. Okay. Whew, I'm tired. We're almost done, guys. 2 more pages. In short, it is settled law in the Second Circuit Court. The anti-SLAPP statutes inapplicable in federal courts. While the Second Circuit has not expressly taken up the same question as the New York anti-SLAPP law, virtually all the courts in the Southern District of New York that have done so found that La Liberté applies with equal force to bar the application of that law in federal court because it imposes a burden on plaintiffs that is inconsistent with the Federal Rules of Civil Procedure. G, the motion to strike should be denied, or at most granted with leave to amend, which I've only heard 7,000 times tonight. The timeline contained in Exhibit A. The timeline with the amended complaint, guys, that huge long timeline that he submitted, was attached to the first amended complaint in an effort to provide a complete and chronological account of the facts underpinning the Wayfarer party's claims and to incorporate as much evidence as was then known in support of those claims. Nevertheless, the Wayfarer parties acknowledge the mountain of evidence in support of their claims must seem overwhelming to the Sloan parties. Should the court grant the motion to strike with leave to amend, the Wayfarer parties will undertake to judiciously incorporate the allegations and evidence from Exhibit A into the body of the complaint, and the hope that the Sloan parties will then find it less burdensome to mount a defense to the Wayfarer parties' allegations if they can. Oh my God, it's the end! Conclusion! For all the reasons set forth herein, and to be presented at oral argument should the court order it. Ooh, interesting. The Wayfarer parties respectfully urge that the court deny the motion in its entirety. In the alternative, should the court be inclined to grant the motion in whole or in part, the Wayfarer parties respectfully request that they be granted leave to amend their complaint as stated herein. Jesus Christ. Oh, there's a footnote. Defendant in the New York Times has filed a simultaneously pending motion to dismiss, and there remains a possibility that Lively and or Reynolds may yet move to dismiss. And I think that would be due, guys, in 2 weeks if they did do that. That's not to say they won't file it earlier. It just means I think it's due on the 20th. A lot of these responses were due on the 20th. So, except for the lawsuit with Jed Wallace in Texas, today they extended the deadline for Blake Lively to respond until I think it was April 4th or April 6th or something. It was supposed to be on Monday. So now I was like, I'm not a patient person. I really wish it wasn't being extended, but I understand the world doesn't revolve around me. So without conceding the merits of this motion or any other pending potential motion to dismiss, the Wayfarer parties propose that the court set a deadline for amending the complaint that falls after all pending or potential motions to dismiss are decided, to allow the Wayfarer parties to correct any identified defects at once, and to avoid burdening the court's docket with seriatim amendments. What's seriatim mean? Hang on, I need to know this now. Oh, seriatim. That's how you say that. Taking one subject after another in regular. Oh, I see. Okay. Guys, we're learning words. We were learning sign language earlier today during the hearing. So, 9:30 PST. Yes, please join my friend Omar at 9:30 PST if you can. If I'm awake, which is not a far stretch considering last night I was on his stream until 2 a.m. If I'm awake, I will be there and I will talk to you guys there. If not, then I will not talk to you because I'll be asleep, and I will be very happy about that. Guys, I have a huge favor to ask you. Because we stayed up reading this all together, a friend of mine who is streaming right now, I really need you to give him a bacon bot raid. If you don't know what a bacon bot raid is, when I end this stream, it will redirect you to him. And what I'm asking you to do is spam his chat with Lauren and then bacon and robots. It's a fun time. Sort of. I get a kick out of it. I mean, you won't see me, but I'll be cackling over here. So I do want to read these super chats really quick. Shay Cat, thank you for the 5. Keep up the good work. You do great for doing this in your attic. Thank you very much. I can't wait until one day I can move this desk and everything downstairs. However, it's going to be a very long time because I am not that active. Adrian Clark, thank you for becoming a YouTube member. If you become a YouTube member of my channel today, I posted a video of Butter, my dog, dancing for all of our new YouTube members. So go check that out if you're a member and you haven't yet. It's in the post tab or the shorts tab on my YouTube channel. KKB, thank you for the 5. They are all our battles is exactly right. I totally dig this format. Dude, I will be here the second I see it, as often as I can. Sometimes I have to work, so I can't. But if I can, I will. Anyways, I'm sending you to my friend. Hear me out. Please spam him. It's going to be crazy. If this works out like I want it to, just spam him with bacons. Just spam him with bacons and bots. And people will be very confused, but he'll also be very excited. So tell him Lethal Lauren sent you or Court of Random Opinion sent you or whatever. I don't care. Just send bacons and send robots. All right, guys. Thank you. I will see you tomorrow. Bright and early, I'm going to get up and record a highlight video of like the top few things I saw in that filing, and we'll talk more tomorrow. Appreciate you guys. See you soon. Again, don't forget bacons and robots.